In the process of preparing an estate plan, most qualified attorneys put in an option called a disclaimer option into the will of the person who's leaving the assets. Now, as a financial advisor, I'm asking the families very often, do you have a disclaimer option? And the answer is always the same. What's a disclaimer option? My only reply is, if you don't know, how do your kids know? Because they're the ones who have to exercise that. Well, to put it briefly, a disclaimer option is the right that anybody in America has, guaranteed by federal law, to refuse to accept any or all of their inheritance. Now, you must be asking yourself, why would somebody do that? Well, a properly done plan says that if my children disclaim any part of the assets, that share will go to their children. And what it does is it allows the child to do tax planning after the parent dies, and very often they can pass assets through themselves onto their children. Their children may be in a much lower tax bracket than they are themselves, and if they're helping with things like college or weddings or maybe a down payment for a house, these may be the best dollars to pass through at that time when they're inheriting. Yet, because most people are never informed, they lose the option, because taking the first dollar from those assets can wipe out the option for the disclaimer, taking away any benefit that went into the careful plan done by the parent. So that's just one of many topics we'll be talking about at our upcoming workshop we're calling Leave Wisely, Inherit Wisely, putting together the parts of the estate plan that the estate planning attorneys didn't tell the heirs. We look forward to seeing you there.